Family civil litigation and employment law requirements, contact us. We also specialize in business, corporate, and charity advice. We are Commissioners of Odds.
Tanlo Solicitors, first floor, Fulmana Terrace, Friars Road, Coventry, CV1,
or call us on +44 632 323. Tanlo Solicitors.
Welcome again to this episode of Legal Updates with Tanlo Solicitors. My name is Andrew Nyamayaro and I'm a solicitor at Tanlo Solicitors. This week, as you might have guessed, I'm going to discuss the issue that is topical amongst our community of Zimbabweans in the United Kingdom. For the past week or so, there's been a detention of a lot of Zimbabweans. Some of them have been detained when they've gone to report at a reporting center. Some have been raided in their accommodation and they've been rounded up. And some who were still serving their prison sentences, for example, have just been served with removal or deportation papers whilst they are being a detention center or a prison establishment here in the United Kingdom. The information that we have received and which is confirmed is a chartered flight that is there on the 21st of June, which is next week, which will fly to Robert Mugabe. At the moment, we do not have the exact time or airport from which it will take off, but people have been served with documents to say that they will be on a plane on the 21st of June. And as you would imagine, people are trying to challenge the removal directions. They are making further submissions, new claims, anything to try to help them, contacting their MPs and so forth, so that they can be able to challenge the removal, the administrative removal, or the deportation. If you have received or if you have been detained by the Home Office, it is important for you to seek legal advice. There's legal advice. Some lawyers will charge a fee, and some lawyers will put you on legal aid if your case qualifies for legal aid. It is important, if you have not made any application at all, an application, whether it's an asylum application or it's an application that is based on family life or human rights, as soon as possible. Time is really of essence under the circumstances. If you had already submitted an asylum or a human rights application that was refused or rejected previously, you need to make a fresh claim, which is also known as further submissions. The new evidence or new circumstances that were not in existence at the time when you made the application or that was rejected, that was dismissed by the courts. A person can make an asylum application mainly on the basis of political opinion, religion, nationality, race, or a membership of a particular social group. Membership of a particular social group means that someone is being persecuted because of a natural characteristic that is on them. For example, if someone is a woman and they're being persecuted because they are a woman, or they are gay or lesbian, or they've been in a love relationship, or some women have been subjected to FGM. So it covers a lot of claim asylum. And if you have been detained and you fall into those brackets, you might consider to do an asylum case. Human rights based on family life in the United Kingdom, where you've got a wife or a partner and children, or if you've got international ties, it can be based on medical grounds. I've received a lot of inquiries on people on medical grounds saying that can they make further submissions on medical grounds. That is known as Article 3. Well, it's normally Article 3 in light with Article 8. But for medical, the host country where you're going to go does not have a good medical facility or a medical system to look after you when you get there, and you will be difficult conditions because of that. So you can make a fresh claim, you can make a new application. I have been in contact, or my colleagues in the profession, other lawyers in this firm or other firms whom I speak to have been in, for example, clients who had never made a claim on their own behalf. We are referring to clients who came as young children. They have been relying on mom or dad on the papers, but unfortunately, along the way, they've unfortunately had a criminal conviction, and now they have to deal with this situation on their own. So, again, legal advice so that they can be advised accordingly whether to continue relying on the parents when they are now adults themselves, or to, for example, if they now have their own partners or their own children, it is important to bring this to the attention of the Home Office. Because the date is on the 21st of June, time is really of essence. So when you submit your fresh claim, if you have got a conviction through the criminal directorate, you fax it, you email it, you have to call them to confirm because they take their time to deal with the matters. And if you have to ask them to cancel your directions. If they do not cancel your removal directions, it is important that you try to submit an injunction application, judicial review application for you to be able to challenge them that the ticket can be cancelled or that you cannot be removed from the United Kingdom. So you need to do an injunction as soon as possible. Most practitioners are very careful when they are doing injunctions or applications for judicial review, because if you submit cases that do not have a merit, you risk the court itself castigating you in the decision of that particular application. But it is a way that is open to individuals to make an application for an has refused or have neglected to cancel your ticket or your removal directions once you've submitted your fresh claim or your new application. These injunctions are done in upper tribunal. Some people are receiving the removal direction documents, and the documents is that you can do to make further submissions or to challenge the removal directions. And because time there's very short time that is left, and without making it an urgent case, then you might not be able to that are there. Assuming that you are not removed from the United Kingdom and you are still in detention or in prison or wherever you are being held, you also and for you to make an application for bail, you need to just try to show that you are not at a flight risk, you comply with the conditions that have been imposed, or is going to be at the Home Office, and they might ask you to have a bail address. If you don't have your own address, then you might have to ask some bail addresses to help you with the bail address, which is recognized by the court and the Home Office. If you have got a probation officer, they might help you. It would also be to your advantage if you have at least one or two financial guarantors who stand with you in statements to show that they'll help you to abide by the bail conditions. And if you don't abide, then they are duty obligated to inform the court and the Home Office that you have breached your bail conditions. If you have been detained by the Home Office, it is important for you to or that is a new application altogether, or a fresh application, further submissions, or it's also important for you to notify your friends, family, and relatives of what is happening. And if active MP, it's also important to approach your MP so that they can contact the Home Office on your behalf. And if you can also, or your relatives or party organizers can also approach the media. We have seen some articles that are in the media that are being reported. I've been approached by a few that wants to know what is happening at the moment. And it's also important maybe for lawyers to get together and see if anything can be done, which is something that is being done in the background at the moment to instruct counsel or barristers that are knowledgeable to Zimbabwean cases, with the hope either to challenge the policy itself of en masse removal of Zimbabweans, or to handle cases on a case-by-case basis. There are some people who have been in this country, the United Kingdom, for nearly 20 years or over 20 years. So it is important for you to consider this route if you do not have legal leave to remain in the country. So if you've got 20 years or just over 20 years, you can make an application on that basis if you gather all your evidence. If you've got children, family life, a partner that you have, you might also consider to bring that to the attention of the Home Office together with the evidence that you have. So as you'd imagine, this is a pretty busy period for TAN law solicitors, for other firms that are helping Zimbabweans, so much that hopefully by the 21st they will not be removed from the country. If you've got any questions relating to the detention, administrative removal or a deportation of Zimbabweans, you can contact us, TAN law solicitors, or any other lawyer that is able and have got capacity to help you under the circumstances. Thank you.